Hello everyone, I'm Anu, an engineer and a law graduate, and I welcome you to my channel where law meets logic and learning becomes easy. Welcome back to part 3 of our environmental law series. In this video, we'll be diving deeper into two powerful legal tools that play a crucial role in protecting our environment in India. The Environment Protection Act 1986, the Air, Prevention and Control of Pollution Act 1981, and the Indian Forest Act 1927. Whether you're preparing for exams or just eager to understand how the law empowers citizens and authorities to fight pollution and safeguard nature, you're in the right place. Let's continue where we left off. 5. The Environment Protection Act 1986. Introduction. The Environment Protection Act 1986, EPA, is the umbrella legislation enacted by the Indian Parliament in the aftermath of the Bhopal gas tragedy of 1984, one of the world's worst industrial disasters. Recognizing the urgent need for a comprehensive environmental framework, this act was passed under Article 253 of the Indian Constitution, enabling Parliament to enact laws for implementing international treaties, specifically the Stockholm Conference of 1972. This act serves as a comprehensive legal tool for the protection and improvement of the environment and provides the central government with sweeping powers to regulate and control environmental pollution. The objectives of the Act. The main objectives of the Environment Protection Act 1986 are protection and improvement of the environment, to implement the decisions made at the Stockholm Conference, to provide a framework for the coordination of activities of various regulatory agencies, to lay down standards for environmental quality and emissions, to give the central government broad authority to prevent environmental pollution. 3. The scope and applicability. The Act extends to the whole of India, including Jammu and Kashmir, post-abrogation of Article 370. It applies to air, water, land, and the interrelationships among them. It supplements other specific environmental laws such as the Air, Prevention and Control of Pollution Act 1981, the Water, Prevention and Control of Pollution Act 1974, the Forest Conservation Act 1980, Wildlife Protection Act 1972, Vaki Definitions Section 2. Environment includes water, air, land, and the interrelationship which exists among and between them and human beings, other living creatures, plants, microorganisms, and property. Environmental pollutant. Any solid, liquid, or gaseous substance present in such concentration that it may be injurious to the environment. Environmental pollution, the presence of pollutants in the environment. Hazardous substance, any substance or preparation which due to its chemical or physico-chemical properties or handling is liable to cause harm. The powers of the central government, Section 3. The Act gives extraordinary powers to the central government to take all necessary measures to protect and improve environmental quality. These powers include planning and executing a nationwide program for the prevention and control of pollution, laying down standards for the quality of air, water, and soil, restricting areas for certain industries to protect the environment, establishing procedures and safeguards for handling hazardous substances, carrying out investigations and research relating to environmental problems, constituting authorities or delegating powers to regulate environmental pollution. This centralization of authority ensures uniform standards and coordinated action across the nation. 5. Powers to issue directions, Section 5. Section 5 empowers the central government to issue directions in writing to any person, officer, or authority. These may include directions to close, prohibit, or regulate any industry or its operations, stop or regulate the supply of electricity or water to an industry. This provision makes the EPA one of the most powerful tools in the Indian environmental legal system. 7. Prevention and Control of Environmental Pollution, Section 7 and 8. Section 7 prohibits the discharge of any environmental pollutant in excess of the prescribed standards. Section 8 requires persons handling hazardous substances to comply with safeguards and procedural requirements to prevent accidents and environmental harm. Vacant. Penalties for contravention. Sections 15 to 17. Section 15, violation of the Act or its rules is punishable with imprisonment up to 5 years or fine up to Rs 1 lakh or both. For continuing offences, additional fine of Rs 5,000 per day and possible imprisonment up to 7 years. Section 16 imposes liability on heads of departments or companies, holding them personally liable unless they prove lack of knowledge or due diligence. Section 17. If the offense is committed by a company, every person directly in charge and responsible is deemed guilty unless proven otherwise. 9. Delegated legislation, environment rules and notifications. Numerous rules and notifications have been framed under this Act to address specific areas. 1. Environment Protection Rules, 1986. Laid down emission and discharge standards for various industries. Introduced Environmental Statement, Form V, to be submitted annually. 2. Hazardous Waste Management Rules, 2016. Deals with handling, transportation, storage, and disposal of hazardous waste. 3. Biomedical Waste Management Rules, 2016. Regulates the proper disposal of hospital waste. 4. E-Waste Management Rules, 2016. Imposes responsibilities on manufacturers and users of electronic goods. 5. Coastal Regulation Zone, CRZ notification. Protects coastal stretches and regulates construction and tourism. 6. Environment Impact Assessment, EIA notification, 2006. Mandates EIA reports for certain developmental activities. X. Role of EPA in landmark judgments. Buono, Vellore Citizens Welfare Forum, Union of India, 1996. EPA was used to enforce pollution standards and close down industries violating norms. 2. Indian Council for Environlegal Action vs. Union of India, 1996. Court directed heavy penalties under EPA. Held polluters absolutely liable under the polluter pays principle. 3. MC Metaview Union of India, Ganga pollution case. Relied on EPA to issue directions to tanneries and municipalities discharging untreated waste. 4. Research Foundation for Science vs. Union of India, 2005. SC prohibited import of hazardous waste into India under the hazardous waste rules framed under the EPA. ICSIN interface with other environmental laws. While EPA serves as a parent law, it complements other laws like Air Act and Water Act address specific forms of pollution. Forest Conservation Act addresses deforestation. Wildlife Act protects biodiversity. NGT Act provides for environmental adjudication. Those salient features. Centralized control empowers the center to take nationwide action. Comprehensive coverage covers all forms of pollution and environmental hazards. Preventive approach emphasizes environmental planning and standards. Stringent penalties, strong punishment provisions to ensure compliance. Delegated rulemaking allows dynamic creation of new environmental rules. 3. Criticisms and challenges. 1. Centralization and bureaucracy. Excessive powers given to central government. Lack of decentralization hinders local enforcement. 2. Poor implementation. Rules are often violated without consequences. Regulatory bodies are understaffed and underfunded. 3. Outdated provisions. Some standards and norms are outdated compared to global benchmarks. 4. Lack of public participation. EPA does not explicitly promote community rights or access to environmental justice, like some modern international treaties. 14. Recent developments and reforms. EIA Notification Draft 2020 proposed controversial amendments to EIA rules. Critics claimed it weakened environmental safeguards. Increased use of EPA by courts and NGT to penalize violations. Proposals to consolidate various laws under a single environmental code. Conclusion. The Environment Protection Act 1986 remains a cornerstone of India's environmental legislative framework. It has enabled regulation of hazardous industries, standard setting for pollution control, judicial interventions for environmental justice, and empowered the central government with enforcement powers. While the Act is comprehensive, its success lies in robust enforcement, community participation, and periodic reform to address emerging environmental challenges. Given the ecological crisis India faces, from air pollution to climate change, strengthening this Act is more critical than ever. 6. The Indian Forest Act 1927. Introduction. The Indian Forest Act 1927 is one of the oldest environmental legislations in India, originally enacted during the British colonial period to consolidate the law relating to forests, the transit of forest produce, and the duty levied on timber and other forest products. The Act was not primarily conservation-oriented, but was aimed at regulating access, ownership, and commercial exploitation of forest resources. Nevertheless, over time, it has served as a foundation for forest governance in India and continues to be relevant today, albeit with amendments and supplementary legislation such as the Forest Conservation Act, 1980, and the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act, 2006. The objectives of the Act. The primary objectives of the Indian Forest Act 1927 are to regulate the use and conservation of forests and forest produce, to empower the government to declare areas as reserved or protected forests, to control the movement and transit of forest produce, to levy duties on timber and other forest products, to penalize encroachments, illegal felling, and other forest offenses. 3. Structure of the Act. The Act is divided into 13 chapters and contains 86 sections, providing detailed provisions for classification of forests, regulation of forest produce, control over private forests, imposition of penalties, power of forest officers. IV. Classification of forests under the Act. 1. Reserved forests. Chapter 2, Sections 327. Most protected category of forests under the Act. Only the government has the rights to forest produce and resources. No rights can be claimed in these forests unless specifically granted. Activities such as grazing, hunting, and logging are prohibited unless permitted. Process of declaration involves settlement of rights under Sections 4 to 20. Case law. State of Bihar versus Banshi Ram Modi, 1985. The Supreme Court emphasized that mining activities in reserved forests without clearance from authorities constituted a violation of the Forest Act. 2. Protected forests. Chapter 4, Sections 29 to 34. These forests are less protected compared to reserved forests. Government retains the power to regulate or prohibit certain activities. Rights of villagers, including grazing and minor forest produce, are usually allowed. 3. Village forests. Section 28. Reserved forests assigned to village communities for management, intended to encourage local participation. Rarely implemented effectively in India. V. Control over forest produce and transit. Chapter Fee, Sections 41-44. Section 41 allows the government to make rules regulating the transit of forest produce. Includes setting up checkposts, permits, and penalties. Control over movement helps prevent illegal logging and smuggling of timber. VE. Regulation of forest offenses. Chapter 9. Forest offenses include illegal felling of trees, encroachment on forest land, grazing cattle without permission, setting fire to forests, unlawful hunting and poaching of wildlife. Punishments. Section 6370. Fine and/or imprisonment depending on the offense. Empowerment of forest officers to arrest without warrant and seize produce. Section 52 allows confiscation of tools, vehicles, and produce used in the commission of a forest offense. 7. Powers of forest officers. Forest officers are granted quasi-judicial and policing powers. They can conduct inquiries, search premises, arrest offenders, and confiscate goods. However, misuse of such powers has led to allegations of harassment and human rights violations, especially in tribal areas. Amendments and modern developments. 1. Forest Conservation Act 1980, introduced to complement the Indian Forest Act, restricts the reservation and use of forest land for non-forest purposes. Requires central government clearance for such use. 2. The Forest Rights Act 2006 recognizes the traditional rights of forest dwellers and tribal communities. Overrides several provisions of the Indian Forest Act where in conflict. Empowers Gram Sabhas to decide on forest land use, collection of minor forest produce, and conservation practices. My constitutional provisions supporting forest laws. Article 48A. State shall protect and improve the environment and safeguard forests and wildlife. Article 51A(g). Duty of every citizen to protect the environment and show compassion for living creatures. 7th Schedule. Forests are listed under the concurrent list, enabling both center and states to legislate. X. Judicial interpretations and case laws. 1. T.N. Godavarman Tirumulpad v. Union of India, 1996 ongoing, landmark pill in the Supreme Court. Resulted in a complete ban on felling of trees in forests without prior permission. Expanded the definition of forest to include areas recorded as forest in any government record, irrespective of ownership. Led to the creation of Forest Advisory Committee, FAC, and stricter enforcement of the Forest Conservation Act. To give Banwasi Seva Ashram visit state of Uttar Pradesh 1986, upheld the right of tribal communities to reside in forest areas and earn their livelihood while balancing conservation concerns. 3. Orissa Mining Corporation vs. Ministry of Environment 2013. Supreme Court ruled that Gram Sabha consent is mandatory for any activity in scheduled tribe forest dwellers areas under the Forest Rights Act. Well, criticisms of the Act. 1. Colonial legacy. designed to serve colonial economic interests, not ecological conservation. It often led to the displacement of tribal communities. 2. Ignoring community rights. Centralized control undermines local knowledge and customary practices. Rights of indigenous communities were not originally recognized. 3. Bureaucratic inertia. Implementation is often rigid and outdated. Forest departments prioritize revenue generation over ecological concerns. 4. Human rights concerns. Forest officials have been accused of using arbitrary power, especially in areas inhabited by tribal communities. Recent developments. 1. Proposed Amendment Bill 2023 aims to redefine forest to exclude lands not notified as forest or recorded as forest in government records. Exempts several categories of land from forest clearance requirements. Critics argue it will facilitate deforestation and commercialization, while the government claims it will streamline approvals and promote afforestation. 2. Afforestation and compensatory measures. Under the CAMPA Act, Compensatory Afforestation Fund Act 2016, funds collected from industries are to be used for afforestation. Still, effectiveness and transparency remain questionable. 13. Role of judiciary and public interest litigations, PILs. Judiciary has played a proactive role in interpreting the Act for conservation. The Supreme Court Monitoring Committee, formed under the Godavarman case, ensures compliance with forest laws. PILs have helped expose illegal logging, mining, and encroachment. 14. Conclusion. The Indian Forest Act, 1927, while a foundational statute, is largely a product of colonial administration and is in dire need of reform. However, its classification of forests, control mechanisms, and penalty provisions still form the bedrock of forest governance in India. Reforms such as the Forest Rights Act, 2006, and proposed amendments to the Indian Forest Act must strive to balance conservation and livelihood needs, protect biodiversity, and promote community-based forest management. To ensure forest protection in the 21st century, India must integrate scientific forest management, tribal rights, climate resilience, and transparent governance into the statutory framework. 7. The Air, Prevention and Control of Pollution Act, 1981. As introduction. The Air, Prevention and Control of Pollution Act, 1981, hereinafter referred to as Air Act, was enacted by the Indian Parliament in response to growing concerns about air pollution and after India's participation in the United Nations Conference on the Human Environment held at Stockholm in 1972. This act provides a comprehensive framework for the prevention, control, and abatement of air pollution, and aims to establish mechanisms for enforcing air quality standards and regulating industrial emissions. It also gives wide powers to pollution control boards at the central and state levels. Objectives of the Act: to prevent, control, and abate air pollution; to establish central and state pollution control boards, CPCB and SPCBs; to regulate emissions from industrial plants, vehicles, and other sources; to provide for the designation of air pollution control areas; to ensure coordination between the center and the states regarding air quality management. 3. Definitions and scope. Air pollutant, Section 2A. Any solid, liquid, or gaseous substance, including noise, present in the atmosphere in such concentration as may be or tend to be injurious to human beings or other living creatures or plants or property or environment. Air pollution, Section 2B. The presence of any air pollutant in the atmosphere. Emission, Section 2J. Any solid or liquid or gaseous substance coming out of any chimney, duct or flue or any other outlet. IV. Important provisions and structure. The Act comprises 7 chapters and 54 sections, each dealing with a different aspect of air pollution control. 1. Chapter 1, Preliminary, Sections 1 to 2. It extends to the whole of India. Section 2 defines key terms including air pollutant, emission, and chimney. 2. Chapter 2, Central and State Boards, Sections 315. Establishes the Central Pollution Control Board, CPCB, under Section 3. Provides for the constitution of State Pollution Control Boards, SPCBs, under Section 4. CPCB coordinates activities of SPCBs, provides technical assistance, and formulates nationwide programs. 3. Chapter 3, Powers and Functions of Boards, Sections 16 to 18. Powers of Central Board, Section 16. Advising the central government, coordinating activities of state boards, laying down national air quality standards. Powers of State Board, Section 17. Planning and executing programs for air pollution control, advising state governments, Inspecting pollution control equipment and industrial processes. Establishing emission standards. V. Air pollution control areas, Section 19. The state government, in consultation with the SPCB, may declare air pollution control areas. Industries within such areas must obtain prior consent from the state board before establishing or operating. V. Consent mechanism, Section 21. Prior consent for establishing or operating industries. No person shall, without the previous consent of the SPCB, establish or operate any industrial plant in an air pollution control area. Consent must include details about emissions and pollution control devices. The board may refuse, grant, or revoke consent. 7th Emission Standards, Section 22. No person operating an industrial plant shall emit any air pollutant in excess of the standards laid down by the board. Violation is punishable under Section 37. The 8. Powers of the boards. Power to inspect and take samples, Section 24 to 26. Board officers may enter premises, inspect equipment, and collect samples. Procedures for sampling and analysis are laid down to ensure fairness. Power to give direction, Section 31. Boards may issue binding directions to any industry or authority. Includes closure of industrial units, disconnection of electricity, etc. 9. Penalties and legal provisions. 1. Section 37. For failure to comply with Section 21 consent or Section 22 standards, imprisonment may extend up to 6 years and a fine or both. 2. Section 38. Provides penalties for obstructing board officials or damaging board property. 3. Section 3941. Covers general penalties and offenses by companies and government departments. X. Judicial interpretations and landmark cases. 1. MC Mehta v. Union of India. Taj Trapezium case. AIR 1997 SC 734. Supreme Court ordered relocation or conversion of industries near the Taj Mahal to protect it from acid rain caused by air pollution. Directed the use of CNG and cleaner fuels. Recognized right to a pollution-free environment as part of Article 21 of the Constitution. 2. Indian Council for Enviro Legal Action vs. Union of India, 1996, 3 SCC 212. Held industries liable for air and groundwater pollution under the polluter pays principle. The 3. Vellore Citizens Welfare Forum via Union of India, 1996. 5. SCC 614-7. SC emphasized sustainable development and strict compliance with environmental laws, including the Air Act. 4. MC Mehta v. Union of India Vehicular Pollution Case. AIR 1999 SC 301. Directed the phasing out of old diesel vehicles in Delhi. Ordered introduction of Bharat Stage Emission Standards. Laid down comprehensive guidelines for urban air pollution control. 8. Institutional mechanism, central and state boards. 1. Central Pollution Control Board CPCB. Technical arm of the Ministry of Environment, Forest and Climate Change. Responsible for laying down National Ambient Air Quality Standards, NAQS. Publishes Air Quality Index, AQI. 2. State Pollution Control Boards, SPCBs. Implement CPCB guidelines. Grant or revoke consents to industries. Conduct inspections and monitor emissions. 2. Limitations and challenges. 1. Poor enforcement. Lack of manpower and resources in SPCBs. Inadequate real-time monitoring. 2. Urban air pollution. Rapid urbanization, vehicular emissions, and construction dust are rising. Lack of effective coordination between local bodies and boards. 3. Legal loopholes. Industries sometimes operate without valid consent. Light penalties deter compliance. 4. Overlapping jurisdiction. Duplication and conflict between Environment Protection Act, Air Act, and Motor Vehicles Act. 20. Complementary legislation. 1. Environment Protection Act, 1986. Provides overarching powers to the central government. Authorizes setting of air quality standards, regulating noise and hazardous emissions. 2. Motor Vehicles Act, 1988, amended in 2019. Regulates vehicular pollution. Imposes penalties for failing emission tests and encourages EV adoption. Part the recent developments and reforms. 1. Commission for Air Quality Management in NCR 2021. A statutory body set up for integrated monitoring of air pollution in the Delhi NCR region. Replaces the Environment Pollution Prevention and Control Authority EPCA. Has power to issue binding directions, coordinate with states, and penalize violators. 2. National Clean Air Program NCAP. Launched by the MoFCC to reduce PM 2.5 and PM 10 levels by 20 to 30% in major cities by 2024. focuses on city-specific action plans, air quality monitoring, and public participation. 15. Conclusion. The Air, Prevention and Control of Pollution Act 1981 is a cornerstone of India's environmental legislation. It establishes a clear institutional and legal framework for combating air pollution. However, over time, the challenges of enforcement, technological gaps, and institutional inefficiencies have hindered its full effectiveness. With rising health concerns linked to air pollution and India hosting some of the most polluted cities in the world, the Act must be implemented rigorously, updated regularly, and coordinated with broader initiatives like the Environment Protection Act 1986 and National Green Tribunal interventions. Only then can the promise of clean air under Article 21, the right to life, be truly realized. Oh. Do like and subscribe for more videos, and don't forget to check out the other videos on this channel as well. In the next part 4, we will continue with the remaining important topics. The Water, Prevention and Control of Pollution Act 1974, National Green Tribunal, NGT, powers and functions, and international treaties related to environmental protection. Please like, share, and subscribe. Thank you for watching.